Afternoon, Canada. I'm Anthony Fury, filling in for Adrian Batra. All right, let's get started. My guests today joining me for legal panel, Ross McLean and Chris Schaefer. Gentlemen, big news story today, Supreme Court decision on tougher sentencing rules, at least what the Harper government wanted to see happen, but the Supreme Court says no. Originally, what used to happen is when you're detained in pre-court, when you're not on bail, you can get 2-for-1 credit for time served. Then it went to 1.5 in certain circumstances if it justifies it. But then the Conservative government thought, well, I don't know about this. It seems like it always justifies it. They're using this all the time. So then they amended a bill to say, hey, 1-for-1 now. We're sticking 1-for-1. The Supreme Court says not cool. What's your take on this, Ross? You did private security, law enforcement. You've looked at this from a number of angles.
Yeah, I look at this from, as I was saying, the ordinary reasonable man's point of view, which is the way the law is supposed to be written and supposed to be interpreted. And you look at where this government has been for the last, since they've been in 8 years or more. They have been working hard to take out loopholes, get tougher on crime, get better sentences on particularly serious violent offenders and sexual offenders. That's the direction they've been going. You know, it's great that this segment is called Straight Talk, your show, because I find that the law in sentencing could be anything but straight talk, Anthony.
Now, in one statement, one of the judges writing for the court, she says, she did this given that vulnerable and impoverished offenders are less able to access bail. The basic idea being, well, you shouldn't be penalized if you're someone who can't get bail, whereas other people who they get bail so they don't serve any time, and then when they get their sentence, it can be reduced by a third or whatnot. So this is just equalizing it to that, is the argument the court gave. Chris, what do you think about that? Do you buy that reasoning?
Well, they've used several reasonings. That was one of them. They've used other reasonings saying that your eligibility for parole, the time that you serve in pretrial or pre-sentence doesn't count towards your eligibility for parole once you are convicted and sentenced. So they use that as an excuse as well. And they've also said that there's harsher conditions in pre-sentence or pretrial jail. So they're using a whole bunch of arguments to argue that the exception under the law that the Tories drafted themselves that said under exceptional circumstances, judges can grant 1.5 credit. They're using that area of the law. The Tories included in their own bill to amend the criminal court, and they're saying basically that now that pretrial, pre-sentence custody is eligible for 1.5 credit for time served.
Now, Ross, they make, I mean, there are two different arguments here between the citizen's sense of justice and that you think a year is a year, but there's so much else that goes on in society where we think, they tell you you're getting paid $80,000 a year, but then we find out you're working until whatever it is, a certain day in May, until your tax freedom day. So nobody's making the sticker price. You think you're paying the sticker price on your car. You got all this fancy stuff. I mean, we're used to numbers that the government gives us being completely false numbers, the actual face values. Aside from the idea of people thinking, well, he got 10 years. I thought he'd serve 10 years. Nobody ever does. Is this inconsistent with the general sense of sentencing we've been seeing for the past decades? The basic idea being that nobody serves their full time anyway.
Well, this is the point that the government has been working to tip the balance back towards victims. We just got through looking at a victim's bill of rights. We just started looking at putting in stronger sentences for violent crimes, putting away people for no parole for up to 40 years. The judges will have that option. So what this government's been doing is attempting to bring the scale back to get a little bit of balance into it. Because you look now, when you go into the checklist for sentencing, the defense lawyers will have maybe 3 pages where they're going to go through all the reasons they can get the sentence reduced. And the Crown has only got so much time to sit there and argue for what the sentence is to be. But let me make this point. I think here's where the Supreme Court really went wrong in their reasoning for this. I mean, the title of this legislation was the Truth in Sentencing Act. One of the things you're supposed to do if you have legislation, and our lawyer friend here can correct me on this if I'm wrong, you're supposed to interpret where there's a gap or you don't understand what's going on in line with how the law was intended. Here, it's to get to that truth in sentencing, the sticker price. But what the court has said in the reasoning was simply this. Their line, they found it inconceivable that the Parliament would mean that somehow you can't get the full credits that are available under the Parole Act. They must have It's inconceivable that they would want this sentence to go 1 for 1 for people. So we're going to rule here that you can do the 1.5 days for pretrial sentencing. It just doesn't make sense to me, and I don't think that the ruling is in line with the spirit of the law and what the legislation was asking for.
Before we go to break, Chris, I want to ask you, there's an example in the Globe and Mail. They give a story of a guy spent 10 months in pretrial custody, but then they took 15 months off of his 8-year sentence. So I go, we're quibbling over, they got the victory, the Conservative government, of going from the 2 for 1 to the 1 to 1.5. I know it didn't fall out exactly the way they wanted it to. And now this is going to become a headline battle. You know, people like to vilify everything the Conservatives do. Sure. Why are they saying this is a hill we've got to die on here when you know, they've eked out, I think they've eked out a 2/3 victory here on this.
They have. The Conservatives,
you know, they're fighting over a couple months, really.
The Conservatives have won. This is not a constitutional striking down of their Truth in Sentencing Act. The Act still stands. It's 1 for 1, a day is a day, except in exceptional circumstances. Now, if I was a legislator...
So why are they going to the hill on this, though, is my question. Why did people even take the stand to begin with?
Because they wanted some form of truth in sentencing, and they got that. They got a day is a day is a day, except in exceptional circumstances. Now what the federal government needs to do, because the Supreme Court's kind of shone the light on and said, hey, legislators need to go back to the drafting table and say, we're going to clarify what are the valid exceptional circumstances in the law. Because right now the Tories, the federal government, left that blank.
So it might come out in the way they want it to if they just sort of do the details.
They can amend the criminal code again and make it clear what is an exceptional circumstance.
All right, we got it.